Hello, friends. This is Ravi Somani. I'm a chartered accountant. Uh, Today's discussion we will be doing on another very important topic is how to reply to a show cause notice. Now, when I say replying to a show cause notice, there are various elements that we need to talk about, right from studying the show cause notice to replying to a notice based on the facts, based on limitations, based on merits, based on legalities, various other aspects. But today's discussion that we would be doing is on a very, very specific and a niche aspect is studying the show cause notice. Now, as you all know, that in case where department uh, is of the view that the taxpayer has short paid the taxes or not paid the taxes or has claimed incorrect ITC or erroneous refund has been claimed, then a show cause notice can be issued under the CGST Act, either under Section 73 or under Section 74. The difference being that under Section 73, the period of limitation would be the normal period of limitation, which is 3 years, and under Section 74, the period of limitation would be the extended period of limitation, which is the period of 5 years from the due date of filing of the annual return. Now, in this particular video, we'll be looking at, let us say, if any of your clients have received a show cause notice from a department, then how do we need to study the show cause notice? What is the methodology that needs to be followed? Now, there are 5 different aspects that one must note while reading a show cause notice. First and fundamental aspect is uh, understanding the facts. Now, in the show cause notice, department, while alleging that the taxpayer has not paid the taxes, would put forth various facts of the case, which would be the information about the business, information about the specific transaction, uh, various provisions or extracts of the contracts, agreements, various statements taken by the directors or recorded from any other persons. So all these facts would be written by the department in the show cause notice to build the case. The first thing is we need to understand the facts as is what is written in the notice, note down, and we cannot just understand or take the facts as is on the face value. We have to cross verify the facts. More often than not, it is seen that the facts which are written in the show cause notice are very much biased and very much drafted in a manner which suits the case in favor of the department. And hence, it is important that we re-verify all the agreements, the various terms of the agreements, the purchase order, understand the transaction independently from the client. And when I say client, from the various layers of the client, not just with the accounts department or the tax department, from the operations department, from the top management, MD, director, or whomsoever who is having a technical knowledge about the particular transaction. We feel that replying to a show cause notice is a desk job, but let me tell you, it is not the case. It is very important that we visit the client's place, understand the transaction, look at the product, make a factory visit, and understand the business of the client. Only then we'll be better able to appreciate the facts. And if you ask me, one fundamental thing which is the most important in replying to a show cause notice is to know the facts of the business. Because if we don't know the facts and if we are just relying on the facts based on what is given on the in the show cause notice, then we are not doing justice to the work that we are doing. Next, very, very important aspect is a legal framework. In every show cause notice, department would rely on certain provisions of the law, certain judgments, certain notifications and circulars. So we need to relook at all the notifications, circulars, or judgments which the department is relying and form whether the interpretation drawn is correct or whether there is an incorrect or a different interpretation being taken about, or reliance is placed on something which is not at all relating to the facts of the current case. Many times we see that department would rely on the judgment, but when we actually go and read those judgments, the facts of those judgments are totally different and nowhere close to the current facts. So it's important that we independently review all these judgments, notifications, circulars, and the various provisions of the act and rules to to prepare ourselves on the legal framework of the department. Once we understand the facts and the legal framework, from reading of both these things, we need to gather the crux of the issue. It is very, very important. Now, every show cause notice, no matter how lengthy it is or how short it is, there would be certain paras in the show cause. There would be certain statements which will be the crux of the show cause notice, based on which the entire issue stands, which is the foundation of the issue. And it is very important for a reader to understand that crux, because the moment you understand that crux, you know how to reply and what to reply to a show cause notice. Next, very, very important that needs to be taken up while studying the show cause notice is that whenever department is levying the penalties, or department is going for the extended period of limitation, that is issuing a notice under section 74 for a period of 5 years, department has to prove that the assessee has has done anything which is fraud or misstatement or suppression of the facts has been done in this particular case. Many times again we see that the notices are issued under section 74 without there being any allegation of the fraud, or without there being a positive allegation of a fraud. So what exactly which is written in the show cause notice that has prompted department to say that the assessee has done fraud? We need to understand that the term fraud, suppression, misstatement are uh, are something where the department is alleging on the very intent of the taxpayer, that the taxpayer has intentionally done this to evade the payment of taxes, and hence the crux or the reasons which the department has highlighted or backed up to allege this particular aspect is something we need to dwell upon while studying the show cause notice. Fourth important aspect to be looked at is the computation verification. Again, many times we see that the notices come for, let's say, 2 crore 32 lakhs and 133 rupees. And when we ask the breakup of that calculation, they would not have the proper breakup. And even if the breakup is there, it is suggested that we re-verify the calculations which have been relied upon, because at times, at least what I have seen out of experience, is that when we re-verify the calculations, there would be duplications, there would be incorrect calculation, or there would be many aspects which are actually not at all correct as per the facts, but still considered in the calculations while calculating the demand of the show cause notice. And same goes with the interest as well. I have seen many cases where the interest is not being correctly computed in the show cause notice. Many times it is not at all given in the show cause notice, but in cases where the demands are raised for interest, there is a calculation or a computation error. We cannot we cannot go on the number in the show cause notice again on its face value. We have to independently re-verify the calculations and the computations. Last and the most important aspect, I would say, is to assess the legality and validity of the show cause notice. Whether the authority issuing the show cause notice is having the power to issue the show cause notice, whether all the legal mandatory requirements or a procedure provided in the law is being followed in the process of issuing a show cause notice, whether the show cause notice is issued within the range of the monetary limit assigned to a particular officer, or within the range of a territorial jurisdiction assigned to an officer, or within the range of a functional jurisdiction assigned to an officer, whether it is mentioned in the show cause notice as to who is the right authority before whom the matter requires to be adjudicated. There are so many High Court, Supreme Court, and tribunal judgments where the matter does not even go in merits, simply based on uh, the legality and validity of the very notice itself, the matter gets quashed. Of course, there can be many more other aspects that one has to look at while studying to a show cause notice, depending upon the facts of each case. But I felt these are the 5 things that one must keep in mind while studying a show cause notice. Thank you very much, and have a good day.